Within the Indian parliamentary system, the Prime Minister and the Council of Ministers wield significant executive authority. They do not just execute laws, they lead the very legislature that creates them. But this setup introduces a specific risk. If a single political party controls a massive majority in both houses, what stops them from using that legislative weight to rewrite the nation's rules and effectively dismantle the opposition? The framers of the Constitution addressed this by looking to the South African model. They established a specific protocol in Part 20, Article 368, designed to regulate how the Constitution itself can be changed. Article 368 doesn't provide one single way to change the law. Instead, it creates an escalating system of difficulty. Depending on which part of the Constitution you want to touch, the mathematical requirements for approval become significantly harder. This tiered structure allows flexibility for minor administrative needs, while remaining rigid for high-stakes changes defining the nation's identity. The process begins when an amendment bill is introduced in either House of Parliament. It can be moved by a government minister or a private member, and unlike many other executive actions, it does not require prior permission from the president. However, the bill must pass through both the Lok Sabha and the Rajya Sabha separately. If there is a disagreement between the two houses, there is no provision for a joint sitting to settle the matter. Each house must agree on its own terms. This is Tier 1, the simple majority. It is the lowest threshold for change, requiring more than 50% of the members who are present in the chamber and voting on that day to say yes. This tier covers administrative tasks like creating new states, altering the boundaries of existing ones, or updating citizenship rules. By utilizing a simple majority cities areas, the Constitution remains agile. It allows the government to manage the logistics of a massive, growing country without the process becoming stalled by procedural gridlock. For more sensitive changes, we move to Tier 2, the special majority. This is a dual requirement. A bill needs the support of 2/3 of the members present and voting, and that number must represent more than 50% of the total absolute strength of the House. This higher bar serves as a protection for civil liberties. It is the mandatory threshold for any amendment seeking to alter fundamental rights or the directive principles of state policy. Beyond these parliamentary hurdles lies Tier 3. This tier is triggered when an amendment seeks to change the federal structure of the country itself. Altering the powers of the Supreme Court, the GST Council, or even Article 368 itself requires the special majority in Parliament, plus a simple majority approval from at least half of all state legislatures. Furthermore, there is no time limit set for the states to give this consent. These escalating requirements make it difficult for a central government to act in isolation. To legally centralize power or strip civil liberties, a ruling party must secure a broad consensus that spans across both the national parliament and a large number of diverse state governments. If a bill manages to clear these majorities and ratifications, it moves to the final procedural step, the desk of the president. In this specific case, the president's role is strictly defined. They must give their assent. They cannot withhold the bill or return it to Parliament for reconsideration. Once signed, the amendment officially becomes an act. Critics point out that this process still grants immense power to the legislature. If a single party controls enough seats and enough states, they could, in theory, push through sweeping constitutional changes very quickly. However, there is one final safeguard that operates outside the voting halls of Parliament, the Supreme Court of India. Through the case of Ananda Bharati case, the court established the basic structure doctrine. It held that while Parliament has the power to amend the Constitution, it does not have the power to destroy it. Even a perfect legislative vote cannot be used to remove fundamental pillars like the secular character of the state or the independence of the judiciary. Ultimately, India's amendment procedure is a calculated democratic compromise. It allows the Constitution to evolve alongside the nation while ensuring that the core framework of the Republic cannot be easily discarded.